Hello and welcome to UGC E-Pathshala project. I am Sheetal Arora, Assistant Professor Criminology at Sardar Patel University of Police Security and Criminal Justice in Jodhpur. And I am going to present a module on legal framework of policing, Police Act of 1861. Let's begin with learning objectives of this module. First, to make the learners understand about the Police Act 1861. Second, to understand various legal framework of policing with respect to Police Act of 1861, to make the learners understand relevance of legal framework of policing with respect to Police Act of 1861 in present time. According to Indian Police Act of 1861, Section 23, it shall be the duty of every police officer promptly to obey and execute all orders and warrants lawfully issued to him by any competent authority. B. To collect and communicate intelligence affecting the public peace. C. To prevent the commission of offences and public nuisances. D. To detect and bring offences to justice and to apprehend all persons whom he is legally authorized to apprehend and for whose apprehension sufficient ground exists. E. And it shall be lawful for every police officer without a warrant to enter and inspect any drinking shop, gambling house or other place of resort of loose and disorderly characters. The Indian Police Act of 1861 was legislated by the British right after the revolt of 1857 to bring in efficient administration of police in the country and to prevent any future revolts. It has continued despite India being transformed from a British colony to a sovereign republic. It is the source for obtaining the state legislation on policing. This act made the police a more efficient instrument in curbing, controlling and detection of crime and criminal activities. It gives each state government the power to establish its own police force. According to preamble of this act, whereas it is too expedient to reorganize the police and to make it more efficient instrument for the prevention and detection of crime. Let us know about some important definitions according to this act. Magistrate of the district shall refer to the chief officer charged with the executive administration of a district and exercising the powers of the magistrate by whatever designation the chief officer charged with such executive administration is styled. Magistrate shall refer to all persons within the general police district exercising all powers of a magistrate. Police shall refer to all persons who shall be enrolled under this act. General Police District shall incorporate any presidency, state of place or any part of any presidency, state or place in which this act shall be ordered to take effect. District Superintendent and District Superintendent of Police shall include any Assistant District Superintendent or other persons appointed by general or special order of the state government to perform all or any of the duties of the District Superintendent of Police under this Act in any district property. Shall mean any movable property, money or valuable security. Now regarding constitution of the force. The entire police establishment under a state government shall for the purpose of this Act be regarded as one police force. It shall be formally enrolled and shall consist of such number of officers and men shall be constituted in such manner as shall from time to time be ordered by the state government. Now regarding superintendents in the state government. The superintendents of the police throughout a general police district shall vest in and shall be exercised by the state government. That means district is subordinate to state government except as authorized under the provisions of this Act. No person, officer of court, shall be empowered by the state government to supersede or control any police functionary. Now regarding Inspector General of Police. the administration of the police throughout a general police district shall be vested in the Inspector General of Police, and in such deputy inspectors generals and assistant inspector generals as the state government shall deem fit. The administration of the police throughout the local jurisdiction of the magistrate of the district shall, under the general control and direction of such magistrate, be vested in a district superintendent and such assistant district superintendent as the state government shall consider necessary. Now, regarding powers of Inspector General, exercise of power, the Inspector General of Police shall have the full powers of a magistrate throughout the general police district. However, he shall exercise those powers subject to such limitation as may from time to time be imposed by the state government. Now, regarding appointment, dismissal, etc. of inferior officers, may at any time dismiss, suspend or reduce any police officer of the subordinate ranks whom they shall think remiss or negligent in the discharge of his duty or unfit for the same, or may award punishment to any police officer of the subordinate ranks who shall be careless or negligent in discharging his duty, or who by any act of his own shall render himself unfit for the discharge thereof. These punishments may be as follows: fine of any amount not exceeding 1 month's pay, confinement to quarters for a term not exceeding 15 days, with or without punishment, drill, extra guard, fatigue or other duty, deprivation of good conduct pay, removal from any office of distinction or special endowment, subject to the provisions of Article 311 of the Constitution and to such rules as the state government may from time to time make under this Act. The Inspector General, Deputy Inspector General, Assistant Inspector General and the District Superintendent of Police. Now, regarding certificates to police officers. Every police officer appointed to the police force other than an officer mentioned in section 4 shall receive on his appointment a certificate in the form annexed in this Act under the seal of the Inspector General or such other officer as the Inspector General shall appoint, by virtue of which the person holding such certificate shall be vested with the powers, functions and privileges of a police officer. Now, regarding surrender of certificate, such certificate shall cease to be effective whenever the person named in it ceases for any reason to be a police officer, and on his ceasing to be an officer shall be forthwith surrendered by him to any officer empowered to receive the same. A police officer shall not, by reason of being suspended from office, cease to be a police officer. During the term of such suspension, the powers, functions and privileges vested in him as a police officer shall be in abeyance, and he shall continue subject to the same responsibilities, discipline and penalties and to the same authorities as if he had not been suspended. Regarding police officers, not to resign without leave or 2 months' notice. No police officer shall be permitted to withdraw himself from the duties of his office unless expressly allowed to do so by the district superintendent or by some other officer authorized to grant such permission, or without the leave of the district superintendent to resign his office, unless he shall have given to his superior officer notice in writing for a period of not less than 2 months or his intention to resign. Regarding police officers not to engage in other employments. No police officer shall engage in any employment or office whatever other than his duties under this Act, unless expressly permitted to do so in writing by the Inspector General regarding power of Inspector General to make rules. The Inspector General of Police may from time to time, with the approval of the state government, frame such orders and rules as he shall deem expedient relative to the organization, classification and distribution of the police force. the places at which the members of the force shall reside, and the particular services to be formed by them, their inspection, the description of arms, accoutrements, and other necessities to be furnished to them, the collecting and communicating by them of intelligence and information, and all such other orders and rules relative to the police force as the Inspector General shall from time to time deem expedient for preventing abuse or neglect of duty, and for rendering such force efficient in the discharge of the duties. Now, regarding additional police officers employed at cost of individuals. The Inspector General of Police or any Deputy Inspector General, Assistant Inspector General, or for the District Superintendent may lawfully, subject to the general directions of the magistrate of the district, on the application of any person showing the necessity thereof, depute any additional number of police officers to maintain peace at any place within the general police district, and for such time as shall he deemed proper, such force shall he exclusively under the orders of the district superintendent, and shall be at the charge of the person making the application, provided that it shall be lawful for the person on whose application such deputation shall have been made on giving 1 month's notice in writing to the Inspector General, Deputy Inspector General, or Assistant Inspector General, or to the District Superintendent to require that police officer so deputed shall be withdrawn, and such person shall be relieved from the charge of such additional force from the expiry of such notice. Regarding appointment of additional force in the neighborhood of railway and other works, whenever any railway, canal, or other public work, or any manufactory or commercial concern shall be carried on or be operation in any part of the country, and it shall appear in the Inspector General that the employment of an additional police force in such place is rendered necessary by the behavior of reasonable apprehension of the behavior of the persons employed upon such work, manufactory, or concern, it shall be lawful for the Inspector General, with the consent of the state government, to depute such additional force to such place and to employ the same so long as such necessity shall to make orders from time to time upon the persons having the control or custody of the funds used in carrying on such work, manufactory, or concern for the payment of the extra force so rendered necessary, and such person shall thereupon cause payment to be made accordingly. Regarding quartering of additional police in disturbed or dangerous districts, state government can legally by proclamation to be notified in the official gazette and in such other manner as the state government shall direct, declare that any area subject to authority has been found be in the disturbed or dangerous state, or that from the conduct of the inhabitants of such area or any class or section of them, it is expedient to the increase the number of police. It shall then be lawful for the Inspector General of Police or other officer authorized by the state government on its behalf to employ any police force in addition to the ordinary fixed complement to be quartered in the area specified in such proclamation as aforesaid, subject to the provisions of subsection 5 of this section. The cost of such additional police force shall be borne by the inhabitants of such area described in the proclamation. Now, regarding awarding compensation to sufferers from misconduct of inhabitants or persons entrusted in land. If in any area in regard to which any proclamation notified under the last preceding section is enforced, death or grievous hurt or loss or damage to property has been caused by or has ensued from the misconduct of the inhabitants of such area or any class or section of them, it is expedient to the increase the number of police. It shall then be lawful for the Inspector General, with the consent of the state government, to depute such additional force to such place and to employ the same so long as such necessity shall to make orders from time to time upon the persons having the control or custody of the funds used in carrying on such work, manufactory, or concern for the payment of the extra force so rendered necessary, and such person shall thereupon cause payment to be made accordingly. Regarding quartering of additional police in disturbed or dangerous districts, state government can legally by proclamation to be notified in the official gazette and in such other manner as the state government shall direct, declare that any area in regard to which any proclamation notified under the last preceding section is enforced, death or grievous hurt or loss or damage to property has been caused by or has ensued from the misconduct of the inhabitants of such area or any class or section of them, it is expedient to the increase the number of police. it shall be lawful for any person being an inhabitant of such area who claims to have suffered injury from such misconduct to make within 1 month from the date of inquiry or such shorter period as may be prescribed, an application for compensation to the magistrate of the district or of the subdivision of a district within which such area is situated. It shall thereupon be lawful for the magistrate of the district, with the sanction of the state government, after such inquiry as he may deem necessary and whether any additional police force has or has not been quartered in such areas under the last preceding section, to declare the persons to whom injury has been caused by or has ensued from such misconduct, fix the amount of compensation to be paid to such persons and the manner in which it is be distributed among them. Now regarding recovery of money payable under sections 13, 14, 15 and 15A and disposal of same when recovered. All money payable under sections 13, 14, 15 and 15A shall be recovered by the magistrate of the district in the manner provided by sections 386 and 387 of the CRPC. For the recovery of fines or by suit in any competent court, all money paid or recovered under section 15A shall be paid by the magistrate of the district to the persons and to whom and in the proportion in which the same are payable under that section. Regarding special police officers, when it shall appear that any unlawful assembly or riot or disturbance of the peace has taken place, or there may be an apprehension that the police force ordinarily employed for preventing the peace is not sufficient for its prevention and for the protection of the inhabitants and the security of property in the place where such unlawful assembly or riot or disturbance of the peace has occurred or is apprehended, it shall be lawful for any police officer not below the rank of the inspector to apply to the nearest magistrate to appoint so many as so residents of the neighborhood as such police officers may require to act as special police officers for such time and within such limits as he shall desire necessary, and the magistrate to whom such application is made shall, unless he sees cause the contrary, comply with the application. Regarding powers of special police officers and refusal to serve as special police officers, every such special police officer shall have same powers, privileges and protection, and shall be liable to perform the same duties and shall be amenable to the same penalties and be subordinate to rule same authorities as the ordinary officer of police. If any person being appointed as special police officer, as aforesaid, shall without sufficient excuse neglect or refuse to serve as such or to obey such lawful order or direction as may be given to him for the performance of his duties, he shall be liable upon conviction before a magistrate to a fine not exceeding 50 rupees for every such neglect, refusal or disobedience. Now regarding village police officers. Nothing in this act shall affect any hereditary or other village police officer unless such officer shall be enrolled as a police officer under this act. When so enrolled, such officer shall be bound by the provisions of the last preceding section. No hereditary or other village police officer shall be enrolled without his consent and the consent of those who have the right of nomination. Police Chowkidari in the Presidency of Fort Williams. If any police officer appointed under Act 20 of 1856 to make better provision for the appointment and maintenance of police chowkidars in the cities, towns, stations, suburbs and bazaars in the Presidency of Fort William in Bengal, is employed out of the district for which he shall have appointed that act, he shall not be paid out of the rates levied under the said act for that district. regarding police officers always on duty and may be employed in any part of the district. Every police officer shall for all purposes in this act contained he considered to be always on duty and may at any time be employed as a police officer in any part of the Journal Police District. It shall be the duty of every police officer promptly to obey and execute all orders and warrants lawfully issued to him by any competent authority, to collect and communicate intelligence affecting the public peace, to prevent the commission of offences and public nuisances, to detect and bring offences to justice, and to apprehend whom he is legally authorized to apprehend, and for whose apprehension sufficient ground exists. And it shall be lawful for every police officer for any of the purposes mentioned in this section without a warrant to enter and inspect any drinking shop, gaming house or any other place of resort and loose and disorderly characters. Now regarding police officer may lay information etc. Any police officer may legally lay any information before magistrate and apply for a summon, warrant, search warrant or such other legal process as may by law be issued against any person committing an offence. Now regarding police officers to take charge of unclaimed property and the subject to magistrates' orders as to disposal. It shall be duty of every police officer to take charge of all unclaimed properties and to furnish an inventory thereof to the magistrate of the district. The police officer shall be guided as to the disposal of such property by such orders as they may shall receive from the magistrate of the district. Regarding magistrate may detain property and issue proclamation. The magistrate of the district may detain the property and issue a proclamation specifying the articles of which it consists and requiring any person who has claim thereto to appear and establish his right to the same within 6 months from the date of such proclamation. Now regarding persons refusing to deliver certificate etc. On ceasing to be police officers, every person having ceased to be enrolled as police officer under this act who shall not forthwith deliver up his certificate and the clothing accounts, appointment and other necessary which shall have been supplied to him for the execution of his duty shall be liable on conviction before a magistrate to a penalty not exceeding 200 rupees or to imprisonment with or without hard labour for the period not exceeding 6 months or to both. Regarding confiscation of property if not claimant appears. If no person shall within the period allowed claim such property or the proceeds thereof, if sold, it may, if not already sold under subsection 2 of the last preceding section, be sold under the orders of the magistrate of the district. The sale proceeds of property sold under the preceding subsection and the proceeds of the property sold under section 26 to which no claim has been established shall be at the disposal of the state government. Now regarding penalties for neglect of duty etc. Every police officer who shall be guilty of any violation of duty or wilful breach or neglect of any rule or regulation or lawful order made by competent authority or who shall withdraw from the duties of the office without permission or without having given previous notice for the period of 2 months, for who being absent on leave shall fail without reasonable cause to report himself for duty on the expiration of such leave, or who shall engage without authority in any employment other than his police duty, or who shall be guilty of cowardice, or who shall be any unwarrantable personal violence to any person in his custody shall be liable on conviction before magistrate to a penalty and exceeding 3 months' pay or to imprisonment with or without hard labour for a period not exceeding 3 months or to both. Now regarding regulation of public assemblies and processions and licensing of the same. The district superintendent of assistant district superintendent of police may, as occasion required, direct the conduct of all assemblies and processions on the public roads or in the public streets or through fairs, and prescribe the routes by which and the times at which such processions may pass. He may also, on being satisfied that it is intended by any person or class of persons to convene or collect an assembly in any such road, street, or thoroughfare, or to form a procession which would, in the judgment of the magistrate of the district or the subdivision of a district, if uncontrolled, be likely to cause a breach of the peace, require by the journal or special notice that the persons conveying or collecting such assembly or directing or promoting such possession shall apply for a license. On such application being made, he may issue a license specifying the names of the licenses and defining the conditions on which alone such assembly or such possessions is to be permitted to take place, and otherwise giving effect to this section, provided that no fee shall be charged on the application for or grant of any such license. Now, regarding powers with regard to assemblies and possessions violating conditions of license. Any magistrate or district superintendent of police or assistant district superintendent of police or inspector of police or any police officer in charge of a station may stop any possessions which violates the conditions of a license granted under the last foregoing sections, and may order it to be an assembly which violates any such conditions as aforesaid, to disperse any possessions, or assembly which neglects or refuses to obey any order given under the last preceding subsections shall be deemed to be an unlawful assembly. Now, regarding police to keep order on public roads, etc. It shall be the duty of the police to maintain law and order on the public roads and in the public streets, through fairs, ghats and landing places and all the other places of public resorts, and to prevent obstructions on the occasions of assemblies and processions on the public roads and in the public streets or in the neighborhoods of places of worship during the time of public worship, and in any case when any road, streets, through fairs, ghats or landing place may be thronged to, may be liable to be obstructed. Now, regarding penalty for disobeying orders issued. Under last three sections, etc., every person opposing or not obeying the orders issued under the last three preceding sections or violating the conditions of any license organized by a district superintendent or assistant district superintendent of police for the use of music or for the conduct of assemblies and processions shall be liable on convictions before a magistrate to fine not exceeding 200 rupees. Nothing in the last four preceding section shall be deemed to interfere with the general control of the magistrate of the district over the matters referred to therein. Now, regarding punishment for certain offences on roads, etc. Powers of police officers. Any person who on any road or in any open place or street or thoroughfare within the limits of any town to which this section shall be specially extended by the state government commits any of the following offences to the obstruction, inconvenience, annoyance, risk, danger of damage of the residents or passengers shall on conviction before a magistrate be liable to a fine not exceeding 50 rupees or to imprisonment with or without hard labour not exceeding 80 days. And it shall be lawful for any police officer to take into custody without warrant any person who within his view commits any of such offences, namely slaughtering cattle, curious riding, etc. Any person who slaughters any cattle for cleans any carcasses, any person who rides or drives any cattle recklessly or continuously or trains or breaks any horse or break cattle, cruelty to animals, Any person who wantonly or cruelty beats, abuses or tortures any animal, obstructing passengers, any person who keeps any cattle or conveyance or any kind standing longer than is required for loading or unloading or for taking up or setting down passengers, or who leaves any conveyance in such a manner as to cause inconvenience or danger to the public. Regarding jurisdiction, any charge against police officer above the rank of constable under this act shall be inquired into and determined only by an officer exercising the powers of a magistrate. Regarding power to prosecute under the law not affected, nothing contained in this sect shall be construed to prevent any person from being prosecuted under any other regulation or act for any offence made punishable by this act, or from being liable under any other regulation or act or any other or higher penalty or punishment than is provided for such offence by the act. Now, regarding recovery of penalties and fines imposed by magistrate. The provisions of section 64 to 70, both inclusive of the Indian Penal Code, and of sections 386 to 389, both inclusive of the Criminal Procedure Code, with respect to fines shall apply to penalties and fines imposed under this act on conviction before magistrate. That notwithstanding anything contained in section 65 of the first mentioned code, any person sentenced to fine under section 34 of this act may be imprisoned in default of payment of such fine, such any period not exceeding 80 days. Procedure until return is made to warrant of distress. Repealed by the Police Act 1861, Amendment Act 1895, Section 14, imprisonment of distress not sufficient. Repealed by the Police Act 1861, Amendment Act 1895, Section 14, levy of fines from European British subjects. Repealed by the Police Act 1895, Amendment Act 1895, Section 14, rewards to police and informers payable to the General Police Fund. Repealed by the AD 1937, limitations of actions. All actions and prosecutions against any person which may be lawfully brought for anything done or intended to be done under the provision of this act or under the general police powers hereby given shall be commenced within 3 months after the act complained of shall have been committed, and not otherwise, and notice in writing of such action and of the cause thereof shall be given to the defendant or to the district superintendent or an assistant district superintendent of the district in which the act was committed, 1 month at least before the commencement of the action. Tender of amends. No plaintiff shall recover in any such action if tender of sufficient amends shall have been made before such action brought, or if a sufficient sum of money shall have been paid into court after such action brought by or on behalf of the defendant, and though a decree shall be given for the plaintiff in any such action, such plaintiff shall not have cost against the defendant unless the judge before whom the trial is held shall certify his approbation of the action. Plea that act was done under warrant. When any action of prosecution shall be brought to any proceedings held against any police officer for any act done by him in such capacity, it shall be lawful for him to plead that such act was done by him under the authority of a warrant issued by a magistrate. Such plea shall be proved by the production of the warrant directing the act and purporting to be signed by such magistrate, and the defendant shall thereupon be entitled to the decree in his favour. Notwithstanding any defect of jurisdiction in such magistrate, no proof of the signature of such magistrate shall be necessary, unless the court shall see reason to doubt the being genuine. Police officers to keep diary. It shall be the duty of every officer in charge of a police station to keep a journal diary in such form as shall from time to time be prescribed by the state government, and to record therein all complaints and charges preferred, the names of a person arrested, the names of the complainants, the offences charged against them, the weapons or property that shall have been taken from their possessions or otherwise, and the names of the witnesses who shall have been examined. The magistrate of the district shall be at liberty to call for and inspect such diary. State government may prescribe form of returns. The state government may direct the submission of such returns by the inspector general and the other police officers as to such state government shall seem proper, and may prescribe the form in which such returns shall be made. Scope of Act. This Act shall not be its own operation, take effect in any presidency, state or place, but the state government by an order to be published in the official gazette may extend the whole or any part of this Act to any presidency, state or place, and the whole or such portion of this Act as shall be specified in such order shall thereupon take effect in such presidency, state or place when the whole or any part of this Act shall have been so extended. The state government may from time to time by notification in the official gazette make rules consistent with this Act to regulate the procedure to be followed by magistrate and police officers in the discharge of the duty imposed upon them by or under this Act, to prescribe the time, manner and conditions within and under which claims for compensation under section 15A are to be made, the particulars to be stated in such claims, the manner in which the same are to be verified, and the proceedings including local inquiries if necessary which are to be taken consequent thereon, and generally for giving effect to the provisions of this Act. All rules made under this Act may from time to time be amended, added to or cancelled by the state government regarding authority of district superintendent of police over the village police. It shall be lawful for the state government in carrying this Act into effect in any part of the territory subject to such state government to declare that any authority which now is or may be exercised by the magistrate of the district over any village watchman or other village police officer for the purpose of the police shall be exercised subject to the general control of the magistrate of the district by the district superintendent of police. For conclusion, one may say that the Police Act 1861 created a strong culture within the organization which inhibits its development. The preamble to the Act refers the police as an instrument for prevention and detection of crime. An instrument doesn't work by itself. It has to be used by someone. The Act stipulates the administration of police by a district SP under the general control and direction of a magistrate of the district. Lastly, the use of expression like obey makes one subordinate to the other. The obedience fixation has created a psychology of servitude among the members. The politicians and bureaucrats expect the police to obey orders, whatever be their content. Thank you.